Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to talk about are DUI checkpoints legal? Are sobriety checkpoints legal? We're talking about the situation where the police will block off a road and make every single person driving down that road stop at a checkpoint, and the police will then check to see if you might be drinking or drunk and driving, and in that case, they might pull you over and ticket you for same. And this has caused a lot of controversy. I've been asked about this many, many times, and I've decided to do a podcast and video on it now, primarily because, among other things, it actually has a connection to Michigan, believe it or not. So, what happened originally was that back in the late 1980s, Michigan came up with the idea about doing sobriety checkpoints. And they put a program in place, and the Michigan State Police then set up a sobriety checkpoint in Saginaw, Michigan, a place I'm very familiar with because I worked at a radio station there many years ago. And under the guidelines, checkpoints would be set up at selected sites along state roads. All vehicles passing through the checkpoint would be stopped. The drivers briefly examined for signs of intoxication. In cases where a checkpoint officer detected signs of intoxication, the motorist would be directed to a location out of the traffic where an officer would check the motorist's driver's license, car registration, and if warranted, conduct further sobriety tests. And so there was only one of these conducted before it got litigated. So the first and only sobriety checkpoint in Michigan was conducted in Saginaw County with the assistance of the Saginaw County Sheriff's Department. During the hour and 15-minute duration of the checkpoint's operation, 126 vehicles passed through the checkpoint. The average delay for each vehicle is approximately 25 seconds. Now, that's kind of understating things because I'm sure you will understand that even though each car is only detained for 25 seconds, if it's a highway and we block it and make everyone line up to go through this checkpoint, you're going to be there a little bit longer than 25 seconds. But be that as it may, 2 drivers were detained for field sobriety testing, one of whom was arrested for driving under the influence of alcohol, and a third driver who drove through without stopping was pulled over by an officer in an observation vehicle and arrested for driving under the influence. So I guess, hey, if you know you're drunk, but I wouldn't recommend that. So the day before the operation of the Saginaw County checkpoint, several people filed lawsuits in Wayne County, Michigan, asking for injunctive relief to stop these checkpoints from happening. And a trial was held, evidence was taken, and a judge ruled. And the judge ruled that the checkpoints were violating not just the United States Constitution, Fourth Amendment, but also the Michigan State Constitution. And it's something I have to talk about is that, there's a federal constitution. We talk about, Bill of Rights and all that. But each state has its own constitution. And sometimes the constitutions aren't similar. Sometimes they are. And in this case, Michigan actually has a section that talks about searches and seizures also. So the trial court said this violates both the Fourth Amendment U.S. Constitution and Article 1, Section 11 of the state constitution. So the parties to that case were the Michigan Department of State Police and someone named SITZ, S-I-T-Z. And that case was then appealed to the Michigan Court of Appeals, and the Michigan Court of Appeals upheld the ruling. And then the Department of State Police then applied for leave to appeal at the state Supreme Court level. And I've talked about this previously, that you don't automatically get free appeals. Somebody's got to ask. And the Michigan Supreme Court refused to hear the case, meaning that they were suggesting that there's nothing to do here because the lower court ruling is correct. So the Michigan Department of State Police then appealed this to the U.S. Supreme Court. And it's interesting because I've talked before about Justice Rehnquist, and I did that in the context of civil forfeiture because I've had a lot of people tell me that civil forfeiture must be a liberal thing because it involves taking money. And I've pointed out that no, it's actually, you can go back and find the case that's very important in this, that was authored by William Rehnquist, who is known to be a fairly conservative guy. Well, likewise, he authored the opinion in the case of Michigan Department of State Police versus SITZ, which is 496 U.S. 444. Case came out in 1990. And this is the case where the U.S. Supreme Court said that a sobriety checkpoint, as I just described it to you, is not illegal. It is not a violation of the Fourth Amendment. So I'll have to explain to you what he said because it's very, very important. But among other things, he goes through the whole process of explaining the procedure and the history like I just told you. And then he points out that the trial court applied a balancing test that they'd gotten from a U.S. Supreme Court case called Brown versus Texas, which was only recently decided at that point, which balanced the state's interest in preventing accidents caused by drunk drivers, the effectiveness of sobriety checkpoints in achieving that goal, and the level of intrusion on an individual's privacy caused by the checkpoints. So the court says, look, there's a balancing test here, okay? And we're going to balance these things out and then decide how we find. And they found that this was, in fact, a violation of the Fourth Amendment. So the trial court's findings with respect to the balancing factors were that the state has a grave and legitimate interest in curbing drunk driving. They said that's true. But then they also found that sobriety checkpoints are generally ineffective and therefore do not significantly further that interest, and that checkpoints' subjective intrusion on individual liberties is substantial. And that was the reasoning of the lower court. So it found those three things and said basically, yeah, the state's got the right to fight drunk driving, but the way they're doing it is wrong. It's ineffective and it's too much of a hassle and a violation of the typical person's rights. So Rehnquist said, well, unfortunately, the way they're doing it is actually wrong. So they backed up and they explained how the Supreme Court is going to look at this with respect to the Fourth Amendment. So they agree that when you are stopped at a vehicle checkpoint, if even for just 25 seconds, that is a seizure under the Fourth Amendment. No question, that's a seizure. The question thus becomes whether such seizures are reasonable under the Fourth Amendment. So there's no warrant, they just stopped you at random. Is that reasonable? And Rehnquist wrote, it is important to recognize what our inquiry is not about. No allegations are before us of unreasonable treatment of any person after an actual detention at a particular checkpoint. So he then says, there's no question that drunk driving is a problem. And you have to look then at how much of a hassle is this for the average driver? And he wrote, the weight bearing on the other scale, the measure of the intrusion on motorists stopped briefly at sobriety checkpoints is slight. And at that point, you realize which way he's going on this. So he also says that this bit about checkpoints don't work. He said, this case involves neither a complete absence of empirical data nor a challenge to random highway stops. During the operation of the Saginaw County checkpoint, the detention of each of the 126 vehicles resulted in the arrest of 2 drunk drivers. Now, you can do percentages and math on that and so on, but he said that there have been other things that they've upheld, such as doing a checkpoint for illegal aliens, and they found even fewer in those checkpoints, and that was still upheld. So, in sum, the balance of the state's interest in preventing drunk driving, the extent to which this system can reasonably be said to advance that interest, and the degree of intrusion upon individual motorists who are briefly stopped weighs in favor of the state program. We therefore hold that it is consistent with the Fourth Amendment. The judgment of the Michigan Court of Appeals is accordingly reversed, and the cause is remanded for further proceedings not inconsistent with this opinion. So here's what you have to realize, is that the case that went to the U.S. Supreme Court, they were ruling on just the Fourth Amendment issues. They were not ruling on the Michigan constitutional issues. So when the case got sent back to Michigan, the part of the case saying it was a violation of the Michigan Constitution was not upset. So as it stands right now, DUI checkpoints are illegal in Michigan, as ruled by a court of appeals that said it violates the state constitution, but not the U.S. Constitution. And that's what's going to happen when you need to look this up in your state, is to find out if your state has had a ruling on this, or whether your state's outlawed these things or addressed them through the legislature, because that's happened also. But it's quite possible that your state doesn't have these because they're illegal under a state law. Most of the people who ask me about DUI checkpoints are asking me specifically about the Fourth Amendment. And all I can tell you is Rehnquist and a majority of the U.S. Supreme Court have ruled that the DUI checkpoints do not violate the Fourth Amendment. So I did find a list of the jurisdictions that do not allow these kind of checkpoints, and it's often because they violate the state constitutions. So those would be, according to the list I found, Idaho, Iowa, Michigan, Minnesota, Oregon, Rhode Island, Texas, Washington, Wisconsin, and Wyoming. That'd be 10 states that they're against the law. One other state, Alaska, does not use checkpoints even though it has not made them illegal. They just choose not to. And Montana uses checkpoints frequently. Some states combine their efforts in setting up sobriety checkpoint initiatives, such as the Checkpoint Strike Force, jointly run by Virginia and Washington, D.C., Delaware, West Virginia, and Maryland. And then also in California, they've had some litigation on this issue as well. So whether or not these things violate the Fourth Amendment, the U.S. Supreme Court says no. Whether they violate your state constitution, possibly. So you need to look it up in your state. But if you're in Michigan, the case of Michigan Department of State versus Sitz, that case ruled that they are illegal in Michigan under our state constitution. So are DUI checkpoints legal? Depends on where you are. But they do not violate the Fourth Amendment of the Constitution, at least according to a majority of the U.S. Supreme Court. Questions or comments, as always, comment right below. Otherwise, talk to you later. Bye-bye.